For nearly 70 years, the old Whitmore barn had survived every storm, every winter, and every generation that called the farm home. Then one ordinary Monday morning, Sarah Whitmore opened her mailbox and found an official county order demanding that the barn be demolished within 30 days because it had supposedly never been legally built. Across the road, wealthy developer Richard Turner quietly watched, believing that once the barn was gone, Sarah would have no choice but to sell the last piece of land blocking his expansion. Sarah did not argue with the county, accuse Richard, or rush to accept his offer. Instead, she asked one question that left everyone silent. Has anyone ever opened the original farm records? What no one realized was that the answer would expose a forgotten agreement and threaten everything Richard had spent years planning. Before we begin, tell us in the comments. If the government ordered you to tear down your family's barn, would you obey or search for the truth first? Sarah Whitmore had never imagined that the oldest building on her family's farm would become the center of a county dispute. The weathered red barn had stood long before she was born. Her grandfather had kept draft horses there. Her father had repaired tractors beneath its hand-hewn wooden beams. After Sarah's husband passed away, she converted part of the lower level into shelter for her small cattle herd, while the loft remained filled with the hay that carried the animals through winter. To most people driving past, it looked like an aging farm building with faded boards, a patched metal roof, and doors that no longer hung perfectly straight. To Sarah, it was the heart of everything her family had built. Late one Monday morning, the sound of tires grinding across the gravel driveway pulled her away from feeding the cattle. A white county pickup stopped outside the gate, and two inspectors stepped out carrying clipboards. The older man introduced himself as Mark Ellis from the county building department. His younger colleague, Daniel Price, worked for county code enforcement. Neither appeared comfortable. Mrs. Whitmore? Mark asked. Sarah nodded. He handed her a thick envelope. This is an official notice and order concerning the barn. Sarah opened it slowly. The words near the top immediately caught her attention. Notice of unsafe in structure and order to repair or demolish. The report stated that the county's electronic files contained no approved construction permit for the barn. It also listed several visible concerns observed from the public road, including leaning exterior boards, a damaged section of roofing, and possible deterioration near the eastern foundation. Unless Sarah appealed the order, submitted documentation proving the building's legal status, and arranged a structural evaluation within 30 days, the county could begin proceedings to have the barn demolished. Sarah read the notice twice before looking up. There has to be a mistake. This barn has been here for nearly 70 years, and the county has inspected it before. Daniel shifted uneasily. We're enforcing what appears in the current property file. The database doesn't show a building permit, a certificate of completion, or any protected designation. Did either of you inspect the inside? Sarah asked. Mark shook his head. Not yet. This notice begins the process and gives you the right to challenge the findings. If you have older documentation or an engineer's report, submit it before the deadline. They returned to the truck and drove away, leaving Sarah alone with the envelope. A few minutes later, a black SUV stopped on the county road. Richard Turner stepped out, removed his sunglasses, and looked toward the barn. Richard owned Turner Development, the company that had purchased hundreds of acres behind Sarah's farm. For 3 years, he had tried to buy a strip of her southern pasture so he could build an entrance road connecting his proposed housing development to the highway. Sarah had rejected every offer. Richard had access to his land through a narrow agricultural lane, but it was unsuitable for construction equipment and commercial traffic. Widening it would require additional land, new permits, and approval from several property owners. Sarah's farm stood directly between his project and the shortest route to the highway. I heard the county finally made a decision, Richard said. Sarah held up the notice. You heard quickly. Richard ignored the comment. I'll still honor my last offer. Once that barn is condemned, repairs won't be cheap. Banks don't like financing structures with unresolved code problems, and maintaining cattle without shelter will make this place harder to operate. He handed her a business card. My offer stands for 30 days. After that, the land may not be worth nearly as much to me. Sarah folded the card, placed it inside the county envelope, and walked back toward the barn without responding. Richard remained beside his SUV for several seconds, watching her. He seemed to believe the demolition notice had accomplished what years of negotiations could not. Inside the barn, Sarah inspected the eastern foundation. The lowest boards were weathered, and one roof panel needed replacing, but the central posts remained straight. The stone footings had not shifted. She rested one hand against the old sliding door and remembered something her grandfather had told her when she was a little girl. If anyone ever says this barn doesn't belong here, don't waste time arguing. Find the papers. At the time, Sarah thought he meant the farm deed. Now, for the first time, she wondered if he had meant something else. She barely slept that night. The county notice remained on the kitchen table, with Richard's card tucked inside. How could a barn that had been taxed, insured, repaired, and occasionally inspected for generations suddenly have no legal history? Before sunrise, Sarah carried an old metal document box down from the hallway closet. Inside were decades of family records, land tax receipts, insurance policies, livestock registrations, repair invoices, and handwritten letters from her grandfather. For nearly 3 hours, she searched every folder. She found tax assessments that specifically listed a barn. She found insurance inspections dating back almost 30 years. She even found photographs from county agricultural events showing local officials standing beside the building. Those records proved the county had long known the barn existed, but none was the original construction permit. By mid-morning, Sarah drove to the county records office. A young clerk named Evan greeted her. "I need every record connected to the Whitmore farm," she said. Evan searched the database and turned the monitor toward her. The electronic file contained deeds, tax maps, a well permit, fence applications, and several agricultural use forms. There was no construction plan for the barn. "That's impossible," Sarah said. "My grandfather insisted every building was properly recorded." Evan hesitated. "These are only the digitized records. The county converted most property files about 19 years ago. If a document wasn't scanned, it may not appear here." Sarah looked up. "Where are the original paper records?" "The older collections are stored in the county archive. Most requests are handled through the database now, so those boxes are rarely opened." Sarah requested access immediately. As Evan prepared the form, an older clerk at the next desk glanced at the demolition notice in Sarah's hand. "You should ask for the engineering files as well as the property file," he advised. Older agricultural structures were sometimes recorded under county projects instead of individual building permits. Sarah thanked him and left. The following morning, she arrived at the county archive 15 minutes before it opened. Unlike the modern records office across town, the archive occupied an old brick building behind the courthouse. Dust coated the windows, metal shelves were visible through the glass, and the faded sign above the entrance simply read County Archives. An elderly archivist unlocked the door. His name tag read Walter Green. "I called yesterday," Sarah said. "I'm looking for the original Whitmore farm records, including anything transferred from the engineering department." Walter adjusted his glasses. "Most people ask for digital copies. The digital file is why the county wants to demolish my barn." She handed him the notice. Walter read every page before looking toward the storage rooms behind him. "I've worked here 28 years, and I don't remember anyone requesting the Whitmore collection. Give me some time." He disappeared through a secured door and returned 20 minutes later pushing a cart loaded with 6 archive boxes. Dust covered the lids, and one box carried a faded transfer label dated August 12, 1983. Walter placed a sign-in sheet beside Sarah. "You may examine everything at this table. The originals cannot leave the room, but I can make certified copies of anything relevant." Sarah opened the first box. Inside were yellowed tax receipts, old survey maps, livestock registrations, and handwritten letters. The second contained insurance records. The third held photographs. The fourth was filled with county meeting minutes. Hour after hour, Sarah searched without finding a permit. By late afternoon, she leaned back in her chair. Maybe it really was lost. Walter closed an empty folder. Sometimes the document people need most is inside the box they're too tired to open. Sarah looked toward the final box. It was smaller than the others and tied shut with faded cotton string. Across the lid, someone had written, "Not Discak, original files." Walter checked the archive label before allowing Sarah to untie it. Inside rested an old leather folder stamped with the county seal. Beneath the seal were the handwritten words Whitmore Farm, original records. Walter lifted the folder onto the table and opened it carefully. Every page carried an embossed county seal, handwritten signatures, or an official recording stamp. The first document was the original deed transferring the farm to Sarah's great-grandfather after his military service. The next pages contained surveys showing each structure and property line. Then Walter unfolded a brittle blueprint nearly 3 feet wide. Across the top were the words Whitmore Agricultural Barn, Approved Construction Plan, June 17, 1954. Sarah stared at it. It was approved. Walter nodded and pointed to the lower corner. The county engineer signed it, the building inspector approved it, and the plan was entered into the commissioner's minutes. Clipped behind the blueprint was a completion inspection dated November 1954. The building had not merely been approved. A county inspector had confirmed that it was constructed according to the accepted plan. Everything the electronic file appeared to show was incomplete. But Walter continued reading. Beneath the construction documents was a 1958 county resolution designating the barn as a protected agricultural emergency structure. During the devastating winter of 1957, the Whitmore family had sheltered livestock belonging to several neighboring farms after roofs collapsed under heavy snow. In recognition of that service, the county entered an agreement with Sarah's great-grandfather to preserve the barn as an emergency agricultural shelter. The designation did not mean the structure could never be repaired or removed, but it required a public hearing, a structural assessment, and formal revocation of the resolution before demolition could be authorized. None of those steps had occurred. Walter compared the resolution with the notice Sarah had received. This order should never have advanced this far without a search of the original file. Sarah looked toward another folded document resting beneath the resolution. It was a recorded easement agreement covering the narrow lane beside the barn. At first, she did not understand its importance. Walter opened the original survey and traced the lane with his finger. This route was established for emergency and agricultural access. Neighboring farmers could move livestock, feed, or equipment through it during severe weather. The lane continued past the barn and ended near land now owned by Turner Development. Richard already uses that lane occasionally, Sarah said. For agricultural access, Walter replied. The agreement expressly prohibits commercial traffic, road widening, and permanent construction use without the written consent of the Whitmore property owner and approval from the county. It also says the restriction runs with the affected land, which means it applies to later owners. Sarah followed the faded line across the survey. Richard's development did not need the barn removed simply because the building occupied space. He needed the county to erase the barn's protected status and weaken the recorded agricultural restrictions surrounding the lane. If the barn were demolished and the old agreement remained hidden, Richard could argue that the historic emergency use had ended, then seek to replace the lane with a commercial entrance. His land would become far more valuable, while construction trucks and future residents would pass through Sarah's farm every day. Walter examined the final pages and frowned. This easement and the protected designation should both appear in the digital index. They affect your property and every parcel that relies on the lane. But they don't, Sarah said. Walter shook his head. No. And that may be more than an ordinary scanning mistake. Sarah left the archive carrying certified copies of the construction plan, completion inspection, preservation resolution, easement agreement, and survey map. The originals remained secured in Walter's custody. For the first time since receiving the demolition notice, she was not relying on family memories. She had official proof. The next morning, she returned to the building department and asked to meet Robert Hayes, the chief building official, whose signature appeared on the notice. Robert invited her into his office after a short wait. Sarah placed the certified documents on his desk. I believe your department issued this order using an incomplete property file. Robert opened the folder with little interest. I reviewed the electronic record, Mrs. Whitmore. There is no permit in the system, and our inspector documented visible deterioration. Sarah slid the 1954 blueprint and completion certificate toward him. Robert frowned, examined the recording stamps, and compared the signatures with the county's historical index. His expression changed. Sarah then showed him the 1958 resolution. This requires a hearing and an engineering assessment before the county can authorize demolition. Robert opened the database and searched again. Nothing appeared. There was no blueprint, completion inspection, protected designation, or restricted easement. I've never seen any of these, he admitted. Neither had anyone else until yesterday, Sarah said. Robert read the notice again. The exterior concerns still need to be inspected. But if these records are authentic, the county cannot presume the barn was illegally constructed, and demolition cannot proceed under this notice. He called the county attorney, then stamped Sarah's order, temporarily suspended, pending record review. This freezes the deadline and stops enforcement while the county verifies the originals, he explained. It is not a final decision, but no one will touch the barn during the review. An employee knocked on his door. Mr. Hayes, the county attorney, is waiting for the Turner Development Access Road meeting. Sarah noticed Robert hesitate. Turner Development. Richard's company was meeting county officials about the same road the forgotten easement restricted. As Sarah walked toward the parking lot, Richard's SUV entered the administration building. He stepped out carrying a thick folder and smiled when he saw her. He still appeared convinced everything was proceeding according to plan. He did not know the original records were already being examined by the county attorney. 2 days later, Robert called. The county accepts that the documents appear authentic, but the commissioners want the chain of custody formally established. They need testimony, showing where the records came from and that they have remained under county control. Sarah drove straight back to the archive. Walter was waiting with an oversized ledger. This is the archive accession register, he explained. Every collection transferred here has been recorded since 1938. He opened the heavy book and stopped at an entry dated August 12, 1983. Whitmore farm coction. Transferred from the county engineering department. Contents included original construction plans, completion inspections, board resolutions, protected agricultural agreements, and survey maps. The documents were listed individually, along with the shelf and box numbers where they had been stored. Walter also located later inventory sheets confirming that the sealed collection was present during archive audits in 1991, 2004, and 2018. This establishes continuous county custody, he said. The originals never left the archive. They were not created recently, altered by your family, or discovered on private property. An official notice arrived the following afternoon. The commissioners had scheduled a public administrative hearing to review the demolition order and determine whether the barn's protected designation remained valid. Sarah, Walter, Robert Hayes, and representatives of Turner Development were asked to appear. Sarah also hired a licensed structural engineer named Laura Bennett to inspect the barn. The county notice had described possible deterioration, and Sarah wanted an honest assessment rather than relying on sentiment. Laura spent nearly 4 hours examining the roof framing, stone footings, posts, siding, and loft. She found 3 areas requiring repair: 2 damaged roof panels, moisture deterioration in several lower boards, and 1 secondary brace that needed reinforcement. The primary frame remained sound. Her written report concluded that the barn was structurally serviceable and could be repaired safely without demolition. The estimated work would take less than 2 weeks and cost a fraction of replacing the building. Sarah submitted the report before the hearing. The commission chamber was full when she arrived. Farmers stood along the back wall, local reporters filled the front row, and several families whose grandparents had used the barn during the 1957 blizzard sat together near the aisle. Richard Turner was seated beside 2 attorneys. Sarah sat with Walter, who had brought the original leather file in a locked archival case. At precisely 9 o'clock, the commission chair struck the gavel. This hearing concerns the notice issued for the Whitmore barn, the legal status of that structure, and the accuracy of the county records used during enforcement. The county attorney spoke first. The building department relied on the electronic database and a preliminary exterior inspection. That database contained no permit or protected designation for the barn. Newly located archive documents now require the county to reconsider the order. Richard's attorney stood. The electronic record available to county employees showed no approved construction permit. Turner did not issue the demolition notice, and his development application is a separate matter. The chair nodded. That distinction is noted. Today, we will consider the evidence. He turned to Sarah, Mrs. Whitmore, what would you like the commission to review? Sarah did not accuse Richard or make a speech. She looked toward Walter. The archivist stood, identified himself for the record, and described how Sarah's request had led him to Archive Room B, Shelf 14. He presented the accession ledger, inventory sheets, and sealed leather folder. One by one, the documents were displayed. The 1954 approved construction plan, the completion inspection, the 1958 preservation resolution, the agricultural easement, and the original survey. Every document carried official signatures, seals, or recording marks. Walter explained that they had remained in county custody for decades. Laura Bennett then summarized her structural inspection. The barn requires maintenance, but I found no evidence of imminent collapse. The primary frame and foundation are stable. In my professional opinion, repair is appropriate and demolition is unnecessary. Robert Hayes acknowledged that the notice had been issued without an interior inspection and without knowledge of the archive file. Had these documents appeared in the electronic index, the department would have followed a different process. We would have ordered a full assessment and referred the protected designation to the commissioners before considering demolition. One commissioner leaned forward. Why were these records absent from the database? The county's information records director, Michael Lawson, walked to the witness table carrying a digitization project binder. 19 years ago, the county converted most paper property records to an electronic system, he said. Every archive collection was assigned for scanning, and every exception had to be logged. He opened the binder and showed the commission an entry reading Whitmore Farm, original records. Scanning status, ket from digitization. Reason, pending consultant review. The chair frowned. Who requested the review? Michael turned to the attached assignment sheet. The consultant's name was Richard Turner. A murmur moved through the chamber. Richard's attorney immediately stood. My client was one of several land record consultants. He had no authority to destroy county documents, and no evidence suggests any record was removed. Michael agreed. The originals were never destroyed or removed, Mr. Turner was asked to review files containing complicated easements before they were scanned. The problem is that this review was never completed, and the Whitmore collection was never returned to the scanning queue. Richard stood and asked to speak. I reviewed hundreds of files during that project. I do not remember this one. If county employees failed to scan it afterward, that is a county administrative mistake. It was the strongest defense he had offered, and for a moment, even Sarah wondered whether the omission might have been nothing more than carelessness. Then the county attorney produced the original consultant agreement. Each file marked pending review required a written recommendation within 30 days. If the consultant could not complete the review, he had to return the file to the digitization manager. The closing report still listed the Whitmore collection as pending under Richard's assignment. Did you submit a recommendation? The attorney asked. I don't recall. Our records contain none. Did you request an extension or return the file to the scanning queue? Richard's attorney objected that 19 years had passed and memories could not be trusted. The chair allowed the question, but cautioned that the hearing was not a civil trial. Richard answered, I have no memory of doing either. The attorney nodded. There is one additional issue. He displayed records from Turner Development's access road application. Attached to Richard's submission was a county database printout showing no protected barn designation and no commercial use restriction on the lane. Richard had relied on that absence while arguing that the road could be widened. Yet his name appeared on the earlier review that had kept the relevant file out of the database. When you submitted this application, the attorney asked, did you disclose that you had once been assigned to review the missing Whitmore records? Richard's face tightened. I didn't remember the assignment. Did you request an archive search before representing that no recorded restriction existed? The county database was the official system. Walter spoke only after the chair recognized him. The database is an index and access tool. It does not erase an original recorded agreement. Anyone conducting a complete title or land use review should examine the underlying deed records and archive references, particularly when the physical lane is shown on an old survey. The chair turned back to Michael. Was the Whitmore file lost? No, Michael replied. It was omitted from digitization after the assigned review was left incomplete. Can you determine whether that omission was intentional? Not from the project log alone. The answer mattered. The records proved Richard's responsibility for an unfinished review and his later reliance on the incomplete database. But they did not prove that, 19 years earlier, he had planned the exact development now before the county. Sarah did not need the hearing to claim more than the evidence showed. The facts were already serious enough. During a short recess, Walter showed the commissioners another record he had found that morning. A 1958 map indexing the protected barn resolution to the agricultural lane. The map confirmed that the barn designation and lane restriction were separate but related legal protections. Demolishing the barn would not automatically erase the easement. However, removing the structure while the original agreement remained hidden would have made it far easier for Turner Development to argue that the emergency agricultural purpose had ended. That explained why the demolition order mattered so much to Richard's project. When the hearing resumed, the chair announced that the county would evaluate the evidence as a whole. The question was no longer whether an old barn looked weathered. It was whether the county had nearly authorized demolition based on an incomplete record, and whether a developer seeking access through the same property had failed to disclose his connection to that incompleteness. The commission chair remained silent for several moments before reading the findings. First, the Whitmore barn was legally approved and inspected in 1954. Second, the county designated it as a protected agricultural emergency structure in 1958. Third, the structure cannot be demolished without the procedure required by that resolution. Fourth, the report of licensed engineer Laura Bennett establishes that the barn is repairable and does not present an immediate collapse hazard. Therefore, the demolition order cannot legally stand. He struck the gavel once. The order is withdrawn. Relief moved quietly through the chamber. Sarah did not celebrate. She closed her eyes for a moment and thought of her grandfather's instruction, "Find the papers." The chair continued. The barn remains subject to ordinary safety and maintenance requirements. Mrs. Whitmore has agreed to complete the repairs identified by the engineer, and the building department will conduct a final inspection when that work is finished. Sarah nodded. She had never asked to be excused from maintaining the barn. She had only asked the county to judge it using the complete record. The chair turned toward her. On behalf of the county, I apologize for the notice issued on incomplete information. Sarah gave a small nod. Thank you. Then the chair faced Richard. This commission is not determining civil or criminal liability today. The evidence does not establish that Mr. Turner planned the current development 19 years ago or intentionally concealed the file for that purpose. It does establish that a review assigned to him was never completed, that the Whitmore collection was excluded from digitization as a result, and that Turner Development later relied on the missing information without disclosing Mr. Turner's prior connection to the file. Richard's attorneys whispered to each other. The chair continued. All pending applications connected to Turner Development's proposed access road are suspended until the county completes a title review, restores the omitted records to the electronic index, and evaluates the applicant's disclosures. The incomplete digitization project will be referred to the county attorney and the state records office for administrative review. That decision did not cancel Richard's entire development, seize his land, or declare him guilty of a crime. It did something more immediate. It stopped him from using an incomplete public record to force a commercial road through Sarah's farm. Without approved access, his construction schedule could not proceed. Lenders would demand updated permits, investors would reconsider deadlines, and Richard would have to find another lawful entrance or negotiate openly with every affected owner. Richard gathered his papers without looking at Sarah. As he reached the chamber doors, he glanced back at the leather archive case. For years, he had trusted the convenience of the newest database. He had never expected his plans to be interrupted by the oldest records in the county. Outside, reporters surrounded Sarah. One asked whether she intended to sue Richard. Another wanted to know if she would now sell the farm for a higher price. Sarah answered carefully. I haven't decided whether any further action is necessary. Today was about correcting the record and protecting the barn. The farm is still not for sale. Walter joined her on the courthouse steps. "Your grandfather would have enjoyed this," he said. Sarah smiled. He would have asked why it took us so long to open the box. During the following 2 weeks, Sarah repaired every defect listed in Laura Bennett's report. A local roofing crew replaced the damaged metal panels. A carpenter removed the decayed lower boards and installed properly treated replacements without disturbing the historic frame. Laura supervised the reinforcement of the secondary brace and confirmed that the foundation remained stable. Several neighbors volunteered to move hay away from the work area and help build a temporary cattle shelter during the repairs. Sarah paid the professionals and accepted only the kind of help neighbors had always exchanged during difficult seasons. When Robert Hayes returned for the final inspection, he walked through the barn slowly, checking the repaired roof, bracing, exits, loft supports, and livestock area. He signed the compliance certificate at a table beneath the same beams Sarah's father had once used to lift tractor engines. "The barn is safe," he said, "and this certificate has already been entered into both the electronic file and the permanent archive index." Sarah smiled. "This time, make sure it stays there." Robert gave a rueful nod. "We're changing the system. Any enforcement case involving a structure more than 50 years old will now require an archive search before a demolition notice is issued." The county also began reviewing other collections excluded from the old digitization project. Most involved harmless gaps, duplicate maps, damaged photographs, or records that had later been scanned under different names. A few contained easements and agricultural agreements that still affected current properties. Sarah's case had exposed a broader weakness. A computer system could make public records easier to find, but it could not guarantee completeness if no one checked what had been left behind. The county restored the Whitmore construction plan, preservation resolution, and easement to the digital index. Each scanned image included a reference directing researchers to the original archive collection. The State Records Office reviewed Richard's old consulting work and found no evidence that documents had been destroyed. It did, however, conclude that he had failed to complete the required review and that the county had failed to enforce its own return procedure. Because Richard had later submitted a development application relying on the resulting omission, the County Ethics Board required Turner Development to file corrected disclosures and reimburse the county for the independent title examination associated with its road proposal. The county attorney left open the possibility of further civil action if additional evidence emerged, but no one pretended the hearing had proven more than it had. The verified facts were enough to stop the road application and protect Sarah's property rights. Richard's company eventually proposed a different entrance from the northern side of its land. The route was longer and more expensive because it required a bridge over a drainage channel, but it did not cross the Whitmore farm or depend on the restricted agricultural lane. Richard appealed several planning conditions, yet he never again approached Sarah with a 30-day offer or suggested that her farm would lose its value without him. The barn remained exactly where it had stood since 1954. That winter, a severe ice storm knocked out power across several rural roads. Two neighboring farmers temporarily moved newborn calves into the Whitmore barn after their electric heaters failed. Sarah opened the lower stalls, brought out extra bedding, and made space beside her own cattle. For the first time in decades, the old barn again served the emergency purpose described in the 1958 resolution. Walter visited the following morning and watched Sarah carry warm bottles toward the calves. "I suppose the county commissioners knew what they were doing after all," he said. Sarah looked around the crowded stalls. "At least the ones who wrote the original agreement did." By spring, the story had become familiar throughout the county. People stopped speaking about the barn as an abandoned structure standing in the way of progress. Agricultural groups requested permission to visit it. A local history class interviewed families whose livestock had been sheltered there during the 1957 blizzard. Sarah agreed to share the story as long as visitors understood that the barn was still part of a working farm, not a museum. Several months after the hearing, the commissioners approved a small plaque recognizing the building's historic emergency role. It did not create new legal rights or replace the recorded resolution. It simply made the history visible. The plaque read, "Whitmore Agricultural Barn, 1954. County Emergency Livestock Shelter since 1958. Sarah installed it beside the main door after the county mailed it to her. Walter arrived carrying a small wooden box. Inside was a replica of the brass shelf tag from the archive location where the Whitmore collection had rested. The original remains county property, he explained. But I thought your family should have a copy. Sarah placed the replica inside a wooden cabinet in the farmhouse, beside certified copies of the blueprint, resolution, survey, and easement. She also created digital backups and gave another set to her daughter. Nothing would depend on a single forgotten box again. One Saturday afternoon, several local families stopped at the farm during a county agricultural tour. Some came to see the restored barn. Others wanted to hear how a missing archive file had nearly affected an entire property. A father lifted his young daughter onto the old fence. She looked at Sarah and asked, "Is this the barn they almost tore down?" Sarah smiled. "It is." The girl studied the repaired roof and weathered red boards. "Why would anyone want to tear it down?" Sarah glanced toward the fields behind the pasture, where survey flags marking Richard's abandoned road route had finally been removed. "Sometimes people stop seeing history and responsibility," she said, "and start seeing only opportunity." As the visitors left, Sarah remained beside the barn. The evening breeze moved the weathered American flag above the loft door. She ran one hand across a beam her grandfather had carved decades earlier. The county had almost erased part of its own history because everyone assumed the computer contained the entire truth. Richard had nearly turned that assumption into a road through her farm. Neither problem had been solved by shouting, threatening, or guessing. Sarah had simply asked for the original records, verified what they contained, repaired what genuinely needed repair, and allowed the evidence to speak. The truth had been waiting exactly where her grandfather said it would be, written down, carefully preserved, and patiently waiting for someone willing to look. If Sarah's story reminded you that history and property rights are worth protecting, tell us in the comments what you would have done after receiving that demolition order. If you enjoyed this story, please like the video, subscribe to the channel, and turn on notifications for more stories about hardworking farmers, forgotten evidence, and ordinary people who refuse to surrender the truth.